Good afternoon, everyone, and hope everyone's week is off to a great start. As a quick reminder, this event will be recorded. If you do not want your personal information to be in the recording, please make sure to check the Ask Anonymously box when submitting questions to the Q&A. Welcome to the second session of the Intro to Privacy series held by the Privacy section of the California Lawyers Association. My name is Hailun Ying, and I'm Privacy and Compliance Counsel at Roblox, and will be moderating this series. First, starting with a little bit of background about the California Lawyers Association, or CLA for short, and the newly minted privacy law section. The California Lawyers Association was formerly part of the State Bar of California. In 2018, there was a separation between the legal enforcement and the voluntary trade association side of the State Bar of California. The newly established CLA became the home of the sections of the State Bar of California, taking over the education, lobbying, and trade meetings, and now represents the vast diversity of California's legal community and the various areas of law practice throughout the state. As part of the CLA, the privacy section is actually also brand new. As we are all well aware, there's been a growing recognition of privacy in the last few years. Various sections within the CLA had subcommittees touching on privacy, but there wasn't a central place for the privacy professionals to gather within the CLA. So for the first time in 35 years, the CLA added a new section, which is how we're able to bring forward amazing privacy content now. In our previous session, we kicked off the series with the fundamentals of privacy, and today we'll be taking a deeper dive into GDPR, which we all know as the regulation that modernized the privacy landscape as we know it today. We're very fortunate to have with us today Paul Lanois, Director of Technology, Outsourcing, and Privacy at the Palo Alto office of Field Fisher. Paul provides detailed guidance on information governance, data protection, privacy, cybersecurity, and digitalization. In particular, he advises businesses on a wide range of domestic and international privacy compliance and cybersecurity matters. Before joining Field Fisher, Paul was Vice President and Senior Legal Counsel at leading international bank Credit Suisse at its headquarters in Switzerland, as well as its Hong Kong office. As in-house Senior Legal Counsel, he advised the bank on various matters, including its global compliance program, cross-border matters, the bank's digital transformation initiatives, and the launch of new online services and products. Prior to Credit Suisse, Paul worked on technology transactions, including from a privacy perspective, at large international law firms in London and Luxembourg. Paul has written extensively on current developments in relation to cybersecurity, as well as American and European privacy laws. He is also a frequent speaker at conferences around the world and leads industry committees and organizations. Paul has received a number of awards, including the Association of Corporate Counsels Top 10 30-somethings Award and the ACC Advocacy Award, as well as the Transatlantic General Counsel of the Year Award at the American Lawyers Transatlantic Legal Awards. He was also named a cybersecurity and data privacy trailblazer by the National Law Journal and had an innovative corporate counsel by Law 360. A quick disclaimer and reminder before handing it over to Paul: the views, thoughts, and opinions expressed in this webinar belong solely to the presenter and not necessarily the presenter's employer, organization, other group, or individual. If there are any questions during the presentation, please again submit them to the Q&A box throughout the event, and we'll cover as many as we can at the end. Now, it's my pleasure and honor to pass the figurative mic to Paul so he can dive into what we have all been waiting for: the GDPR, the splash made in the privacy field, and key areas to focus on to be prepared if and when regulators come knocking. Paul?
Thank you very much, and hi everyone. So I'm delighted to be here with you today to speak on the topic of the European General Data Protection Regulation, also known as the GDPR, as this has had a significant impact on organizations worldwide, and it has also inspired many data protection developments around the world, some of which gave rise to new laws as well in some locations. So without further ado, let's get started. A lot of people ask why data protection is so important. Why do Europeans feel so strongly about data protection that they have enacted a law, the GDPR, which in many aspects is still seen as being the strictest worldwide? Well, in Europe, we have this thing called the European Charter of Fundamental Rights. So it's not quite a constitution, as there are some differences, but it's still the closest thing we have in the EU to a constitution, since it effectively provides constitutional style rights in Europe. And in Europe, we view privacy as being so important that we have actually enshrined the right to privacy and the right to data collection into two separate rights. So we have Article 7, which says that everyone has the right to respect for his or her private and family life, home and communications. And we also have Article 8, which says that everyone has the right to the protection of personal data concerning him or her. So there are two really important things to note from that. The first is that in Europe, privacy and data protection is seen as being so important that it is effectively given the rank and the protection as a fundamental right. In Europe, we care so much about privacy that it's enshrined, privacy and data protection are enshrined as two separate rights under Article 7 and Article 8. Now, some of you may be wondering, I mentioned data protection and privacy separately. So what is the difference actually between privacy and data protection? And one way to think about it is that privacy encompasses notions of trespass on someone's property, maybe bodily privacy, for example, in relation to body searches at airports or in prisons. So those aren't data protection issues. There is no data in relation to that. But those are privacy issues. On the other hand, data protection is concerned with the protection of personal data, meaning that individuals have certain rights in relation to the data which relates to them. For example, they have the right of access, the right of deletion to their personal data, and so forth. So this is really, in a nutshell, the difference, I would say, between the data protection privacy regime that you have in EU and in other countries. So the GDPR is not so much focused on privacy; it is more a data protection law. Now, to truly understand the difference between the US and the European regimes in the area of data protection, I think it's also important to take a step back and to look at the differences between the political systems. So in the European Union, obviously the EU is not a country, it is an economic and political union of countries. It was originally founded at the end of the Second World War as a way of pooling coal and steel production. And what happened was that in 1950, after the Second World War, the nations of Europe, they were still struggling to overcome the devastation following World War II. And the European governments, they decided that one way to help achieve reconstruction was to pool coal and steel production. And in particular, by doing that, it would make war between the historic rivals France and Germany, I quote, not merely unthinkable, but materially impossible. So it was thought correctly that merging the economic interests would help raise the standards of living and would be the first step towards a more unified Europe, ensuring that the factors which led to both World War I and World War II would not arise again. And over time, this union of countries has grown and it now covers 27 member states. Now, due to the variety of countries which are within the European Union, you have a lot of different countries with their own languages, their own backgrounds, and you have actually 24 official languages within the EU. So this also shows you immediately how the complexity, this shows you the level of complexity that you have in the EU that you do not find in other jurisdictions like the US. Since in Europe you have 24 official languages, it means that passing laws and regulations in Europe can give rise to a number of issues and complexities, because even if you have a law which is passed, well, they do need to be interpreted in taking into account language variations as well. And there may be certain difference of interpretation as a result of the translation. And another important thing to bear in mind is that because you have 27 different member states in the EU, well, you find that in each of those EU member states, they have different cultural approaches, different cultural attitudes. For example, the sensitivity of, let's say, the Irish to European data protection would be quite different from the sensitivity of, say, the French, or maybe the Germans, or the Austrians, or the Portuguese. So you will get very different cultural approaches. You will get different linguistic approaches. You would get different legislative approaches, and this leads to the final point about the EU, is that in essence you have three types of laws in the EU. So at the very top, at the highest level, you have what we call regulation. So a regulation is a legal instrument that is passed at the European Union level, and then that regulation would apply throughout the entire EU. So you have one law that applies throughout the entirety of the EU. And then below that, you would have these things called directives, which are legal instruments which are also passed at the European level, and they would also apply throughout the entirety of the EU. But then the difference with a regulation is that the directive is not immediately effective in each EU member state. Instead, what needs to happen when you have a directive is that you need to have each individual EU member state implement the directive within their national law. And when you have this approach of different national implementations of a same EU directive, well, you are likely to end up with difference of approaches as well. Even though the principles may be the same, they would probably adopt different approaches in relation to how they want to enforce a certain principle or whatever. And so that's led to, so we had previously, we had this 1995 European Data Protection Directive, and there were a lot of differences in the interpretation. Even in terms of enforcement, certain countries were stricter than others in implementing, in enforcing the data protection requirements under the 1995 directive. So it was a bit of a mess, if I may call it that way. And that's the reason why the EU member states decided that it was time to change things, that in order to increase the level of data protection within the EU, the only way to go about it was to have a regulation which would be a single consistent set of requirements which would apply consistently throughout the EU. Having said that, there are still variations, even with the GDPR, even with a regulation, you would still have certain areas where there may be some slight variations across EU member states. For example, there may be areas where the GDPR allows room for any member state to apply their own requirements. For example, in relation to the age of children, you have different requirements in the EU. So the GDPR was presented in 2012. It was adopted by the European Parliament in 2016, and then it entered into effect in 2018. And so the GDPR applies to organizations, to businesses in different scenarios. So the first scenario, the most obvious scenario, if I may call it that way, it's where the organization is the organization which is processing personal data is established in the European Union. That's quite straightforward. That's the territorial approach. You're in the EU, you have to comply with the EU requirements. But then, even if an organization is not in the EU, there may be situations where the GDPR apply. For example, if the organization is offering goods or services to residents located in the European Union, or otherwise, if you're monitoring the behavior of residents in the European Union. So this second scenario is really important because that's a scenario that covers a lot of organizations around the world because they have certain activities in the EU. Even if you don't have any brick and mortar business in the EU, but then, for example, you have a website which is available. Which is available and which is open to EU residents. So EU residents can go on the website, they can make a purchase, and so forth. Well, you have a number of case law which states that as long as your website is available in European languages, maybe the website accepts the euro currency. Maybe there is a marketing campaign towards EU resident. Maybe the website has a European domain name, for example, .fr for France, .de for Germany, or whatever. So those are those are the criteria which are often used by the courts and the regulators to say, well, actually, even though you are, for example, a Japanese business or a US business, well, and maybe you don't have any physical activities in the EU, but then that doesn't matter if your website is offering goods or services, as I mentioned, then the GDPR would apply in that case. So what does the GDPR cover? Well, the GDPR covers and sets forth responsibilities for the processing of personal data. And the definition of personal data is very broad under the European General Data Protection Regulation. So the basic definition of personal data is whenever you have any information, any data which relates to an identified or an identifiable natural person. So in other words, as long as information relates to a particular person and could potentially be used to identify that person, well, that's personal data, the GDPR applies. And this means that even if you don't have the name or the physical address of that individual, as long as an individual can be identified directly or indirectly, for example, through the use of an online identifier, a cookie, identification number, an IP address, or the location data, well, that would be personal data under the GDPR. And this leads to a question which often comes up whenever you're dealing with the business, whenever you're dealing with the tech team and so forth. They would often say, well, what is personal data? You know, personal data, shouldn't it be PI? The name, the phone number, the address, and if we just have some kind of identifier, it's just a number. I have no means of knowing who that relates to, so that's not PI, and therefore it's out of scope of the GDPR. Well, it may not be PI. It may not be, PII, but then it's still personal data under the GDPR, because the GDPR's concept of personal data goes well beyond the concept of personally identifiable information. And so in this, on this slide, you can see certain examples of personal data. So of course you have the obvious examples, name, address, and so forth, but then you have also a certain number of information which are much less obvious, but which are nevertheless personal data under the GDPR. For example, an employee number, the device ID, the MAC address of your phone, of your computer, cookies. Maybe you have location data as well. Maybe you would be collecting the browsing history of a customer. Maybe content as well in relation to emails, tags, and so forth. Well, all of the examples that you can see here are personal data under the GDPR. So this is really important, because it's a question which comes up so often whenever you are dealing with a new business project, or when you're talking with the IT team, because everyone still reasons in terms of PII, personally identifiable information, and in many cases, people would come up and would say, well, we only collect an account name, for example. It would just be a generic email address or even a number or whatever, but then it doesn't contain the name. So I don't know who Super Squirrel 007 is. It could be anyone, right? But then, yes, it could. You may not know who that person is. You may not be able to associate that account name with a real life person, but then it doesn't matter under the GDPR. It's still personal data, because it still relates to a person which is identifiable, because there are ways that could potentially be used to identify that person, and therefore it is personal data. Moving forward, so there are as well special categories of personal data, and on the slide here, those have been reproduced, and those those items, as you can see here, those constant data which are deemed to be particularly sensitive from a European perspective. And whenever you're dealing with special categories of personal data under the GDPR, it means that additional restrictions are applicable, and you may not be able to collect that information in many cases. Now, just a word of caution: just because you have special categories of personal data which warrants, in the eyes of the EU legislator, additional protection, doesn't mean that other types of information don't require special protection. For example, in the GDPR, we don't have social security numbers or bank details or children's data, which are listed here, or credit card information. But then obviously, this doesn't mean that that kind of information is not sensitive or protected. It doesn't mean that you should not treat them as though they are not sensitive data. Of course, you should protect them. You should have a heightened level of protection whenever information that you collect or that you process may give rise to identity theft or which may harm the individual. However, what the GDPR is saying is that in relation to the categories which are listed on the screen here, because they are so they're so sensitive, there are even more restrictions which apply whenever there is any handling of such information. So what is processing of personal data? And basically, it covers everything which is listed on the slide here. So processing is not just using the information. If you are simply storing or retrieving or even consulting, well, you are conducting processing of personal information. And the obvious sorry, not obvious, but the example that I like to give a lot of a good example of processing that a lot of people do not think about actually would be whenever you have a call center located in whatever country, so they are accessing the customer records in order to provide assistance, and the fact that the customer support team, for example, located in India or in Poland or wherever, the fact that this team is able to consult and to retrieve the information to assist you, well, they are actually conducting processing. So this often means that whenever you have a global business and you are providing support around the world, maybe you have DevOps teams located in lots of different jurisdictions to provide round-the-clock support to your customers and so forth. Well, it means that you have to be mindful that those operations would be considered processing of personal data under the GDPR, and therefore the GDPR would apply to those scenarios. So on this slide here, I have listed the key GDPR principles on the processing of personal data. So under the GDPR, personal data needs to be processed lawfully, fairly, and in a transparent manner. Data needs to be collected for specific, explicit, and legitimate purposes. So this is the purpose limitation. It means that you cannot use information collected for one purpose for another unspecified purpose. Information needs to be processed in such a way that you're not collecting too much information in relation to the purpose which was specified. That is the data minimization principle. Data needs to be accurate and kept up to date, the accuracy principle. Data needs to be kept in a form that permits the identification of the data subject for no longer than necessary for the purpose for which the data is processed. That is the storage limitation. So this is actually data retention periods. And then finally, you have the requirement that data should be processed in a manner that ensures the appropriate security of the personal data, including the protection against accidental loss, destruction, or damage. So this is the integrity and confidentiality principle, or otherwise the data security principle. And all of those principles which are listed here are really the 6 golden principles under the GDPR, and the number of the different cases and enforcement actions actually turn around those 6 principles. For example, storage limitation. There has been an increase actually in cases in France. The French Data Protection Authority has issued quite a few actually cases in relation to data retention periods. And they should find as well that whenever the French Data Protection Authority considered that data was being stored for a period of time which they considered to be excessive. Moving forward, so the who's who of the GDPR. So you have different categories of actors under the GDPR. You have the first category, the data controllers. So they would determine the purposes and the means of processing the personal data. So they would be the entity who would be saying, well, this is why we collect the personal data, and this is how we want the personal data to be processed. The second category would be the data processors. So this entity would be processing the personal data on behalf of the controller. So the data processor is not choosing anything, actually. They are following the data controller's instructions. And those would be the service providers, for example, in relation to the storage on the cloud and so forth. Those would be good examples of data processors because they are providing you the service, but then they don't control how and why the information is being processed. And then the third category would be the data sub-processors. So they would be the entities which would be following the data processor's instructions. Moving forward, purpose of processing. So this is another requirement of the GDPR. So the data controller has accountability to show a lawful basis for the processing of the information. And here you can see the 4 main legal bases to process personal data. So perhaps it is performance of a contract. So you have entered into a contract with a customer, and therefore you are processing personal data to perform the contract that you have with that customer. The second scenario would be legitimate interest. So this would be the scenario where you have certain legitimate interest in the processing of data, which go perhaps beyond the scope of the performance of a contract. For example, maybe you want to ensure that no fraud is being committed, that you want to ensure security in relation to the connection. So you want to make sure that that customers who are logging onto your website, that they're not trying to launch an attack or whatever. So you have fraud, security, and you have a number of different reasons to conduct certain processing, which would be legitimate interest under the GDPR. Consent, that would be the case where the individual has consented to the processing of data. For example, in relation to cookies, you often see those banners as well, which would pop up on a number of websites where you would have to agree to the use of cookies. You have to agree to the use of cookies on the website. So that's consent. And on this note, I just wanted to mention as well that in relation to data protection requirements, the GDPR is not the only law in terms of where to find data protection requirements, because you have another set of rules, what we call the e-privacy directive, which is often called the cookie directive. And this e-privacy directive is the one which actually provided this requirement that in relation to the deployment of cookies and other tracking technologies, you need to obtain consent from the user. And the reason why you have another directive which would be adding additional rules to the GDPR is that the GDPR is just the general framework, and then you may have certain law which are what we call specialized, and which would then add additional requirements on top of the GDPR. So that's consent, and then legal obligation. That's, for example, the case where maybe you have for example, if you're a financial institution, maybe you have the obligation to collect certain data because you have anti-money laundering laws which apply to you, which require you to keep or to collect certain types of information. Maybe you are just maybe you are an e-commerce service provider, and you have certain legal obligations as well in terms of being able to prove that the transaction was conducted properly. So you have certain obligations which apply. So that's the legal obligation, legal basis. Consent that I mentioned earlier, it's an area which has received a lot of interest as well from regulators recently, particularly in terms of cookies, but then not exclusively, because there has been a lot of cases where the data protection authorities found that organizations say that they were collecting consent, but then actually data protection authorities were of the view that the consent was not valid. So consent under the GDPR needs to be freely given, and one example in this field would be in the context of an employment. So when you have an employee dealing with the employer, under data protection laws in the EU, so under the GDPR, the European data protection authorities have said that because of this relationship between the employer and the employee, where the data protection authorities assume that employees have to agree to whatever the employer says, otherwise they are the fear of losing their job or have some kind of detriment in relation to the job. So data protection authorities in Europe have said that consent given in the employment context is not freely given, and therefore consent is not the best legal basis to choose in an employment context because of this issue of consent being not freely given due to the subordination relationship between an employer and an employee. Consent needs to be unambiguous, and it means that it needs to be clear and explicit. Informed, it means that you have to provide a sufficient amount of information for the individual to be able to provide valid consent. Consent needs to be prior. It means that under the GDPR, you need to actually get the consent first before you can actually conduct the processing. So, for example, in relation to cookies, what data protection authorities in Europe have said is that you need to collect the consent before you place the tracking cookies on a device. You cannot place the tracking cookies first and then ask for consent afterwards under the GDPR. So this is an interesting point because it also means that you have to be careful now in terms of website or even in relation to forms. Consent, it means that you cannot pre-tick boxes as well under the under European requirements anymore. And finally, withdrawable consent. This means that consent that an individual provides can be withdrawn at any time without any detriment. Finally, so moving on to the next point, data transfer. So this is an area which has received a lot of attention recently because so the GDPR allows organizations to transfer personal data freely within the European Economic Area. So that's nice. But then outside of the European Economic Area, so for example, if you want to transfer data from the EU to the United States or to Asia or some other country, well, the main rule or the principle is that you can only transfer data to a location which the European Commission has determined that has an adequate level of protection. So you have certain countries which are on the list, Argentina, Israel, and so forth. And then importantly for us, the United States is not on the list of adequate countries according to the European Commission. So if you want to transfer EU personal data to countries which are not on this list of adequate countries according to the European Commission, well, you need to adopt another transfer mechanism. For example, standard contractual clauses or binding corporate rules. So you have the standard contractual clauses, which are a set of European model clauses which can be used. So what those are you have the European Commission, which issued those model clauses, and it means that you are supposed to use that template. You're not supposed to change the content of the clauses because you're not allowed to. But then you would have to then agree to the terms of those standard contractual clauses, which contain a number of provisions surrounding the responsibilities of each party, the responsibilities of the data importer, and the responsibilities of the data exporter. What to do, for example, if a governmental authority requests access to the data and so forth, and then you will need to fill out certain information as well surrounding what measures you have in place to protect that data. So that the standard contractual clauses would be the most common transfer mechanism for the transfer of data outside of the European Union. I'm not sure if I have time, but then maybe I should mention this as well. There was previously a mechanism called the Privacy Shield Framework, which was used to transfer data from the US to the EU. But then, unfortunately, what happened was that last year, you have a decision from the European Court of Justice, which invalidated the Privacy Shield Framework because the European Court of Justice determined that the Privacy Shield Framework did not provide an adequate level of protection, and that there were concerns as well surrounding governmental access to data in the US. I'm not going to spend too much time on it because anyway, the Privacy Shield Framework no longer exists, but then you should know that there was this decision which came out last year, and then it led to a number of changes. For example, in relation to the standard contractual clauses, it meant that there were new requirements which were issued. For example, now under the standard contractual clauses, you actually have to conduct a transfer impact assessment surrounding the proposed data transfer. You need to make sure that there are sufficient guarantees, sufficient measures in place to protect the information that you transfer outside of the European Union. And there were as well new standard contractual clauses which were issued by the European Commission just a couple of weeks ago. So that's also something which is occupying a number of privacy departments and law firms now, I would say, adapting as well current agreements, current contracts to incorporate the new standard contractual clauses. And so those requirements apply to data controllers and to data processors alike. Transparency. So you have this requirement under the GDPR that the data controller needs to be transparent with the data subjects and provide them with a privacy notice which explains each of the following items. So you need to explain and to provide information on what personal data has been collected, what that personal data will be used for, how long the data will be used for. So that's the data retention period, who that data will be disclosed to? Are you disclosing it to data processors? Where it will be processed? Who the data controller is, and how to exercise data subject rights. In terms of the data subject rights as well, you have under the GDPR a number of obligations which apply. So customers have under the GDPR the right to request access to the information. They have the right to request the deletion of information, the right to change, to amend, to update information, the right to data portability. So this means that customers have the right to request that you provide them the information that you have on them in a machine readable a format which they can then use, for example, if they want to go to a competitor or whatever. Moving on security. So you have under the GDPR, you have this obligation that data controllers and data processors must process information in a manner that ensures the appropriate security of the information which is being held. Oh, and by the way, so in relation to the color scheme, so the reason why data controller is in green and data processor is in purple is because in the table that I showed you earlier, the who's who, I use those colors, and I thought it would make things simpler as well to use the same color throughout the slides, so that especially for those of you who are new to privacy, making the difference between data controller, data processor, it can be quite difficult because you have different requirements which apply to both. So I thought that using the same color scheme throughout would be helpful. So the data controller needs to and is responsible for demonstrating compliance with the requirements under the GDPR. And so this means that whenever a controller is using a processor to process personal information, well, they must document the processor, the vendor due diligence, and the selection process. They need to ask questions, and under the GDPR as well, you have the right as an organization. You actually, sorry, it's not even just a right. You have this obligation actually under Article 28 of the GDPR to collect information, to conduct an audit as well of the data processes if you need to be able to ensure that they are complying with GDPR requirements, and in particularly if that they are securely processing information. So this means that as a data processor, your security practices and your procedures will be a commercial requirement, especially if you're dealing with larger data controllers. There is this expectation that you are able to provide information on what you're doing in terms of security. How do you respond to a security incident? What measures do you have in place to protect the information? Do you have encryption? And so forth. Data breach reporting. So this is the consequence, I would say, of the security requirements. If there is a lapse in the security, what happens? So under the GDPR, if you are a data processor, you need to notify the data controller without undue delay. And then if you are a data controller, you need to notify the appropriate data protection authority within 72 hours from the time when the incident, when you became aware of the incident, unless you have reasonable grounds to believe that the security incident is unlikely to result in a risk to the rights and freedoms of natural persons. So this means, if I try to simplify this means that if there is information which has been accessed by an unauthorized third person, and that information may be used, for example, to conduct identity theft or to identity theft, for example, to open a bank account in the name of the customer or whatever. If there is information which has been accessed in such a way, then that is likely to result in a risk to the rights and freedoms of natural persons. So you have this requirement to notify the Data Protection Authority within 72 hours. Now, 72 hours may seem like a long time, but then in practice, it's a really short time, because you have to get hold of the right individuals. Maybe they're away, maybe some people on vacation and so forth. So this means that what the GDPR is requiring you to have is that you need to have a process in place as well, so that you can handle those incidents within the 72 hours. Yeah, if you don't, especially when you talk to many small organizations, startups, in many cases they would be saying, well, you know what, we don't have any process in place, but then, you know, well, we think we'll be fine, because we are a small organization, we'll be able to handle it. But then when they when they do get hit by a security incident, they realize that, well, 72 hours is really a very short period of time, because, well, people have other commitments, they may be away on vacation. How do you reach those individuals and so forth? So you need to have a process in place to make sure that you're able to respond. So I mentioned notification to the data protection authorities, but then you also have a requirement to notify the impacted individuals if the incident is likely to result in a high risk to those individuals. Moving on, data subject rights. Oh, so I actually did broach upon this earlier, actually. So you have, yeah, under the GDPR, the right of access. You have the right to ask and to get a copy of your own personal data. You have the right to object to direct marketing as well. I mentioned data portability, deletion, the right to object to processing. So how those rights are apply in practice would be that those rights would apply to the data controller. So the data controller has this obligation to respond to those requests whenever a data subject makes those requests. But then it doesn't mean that as a data processor that you don't have to do anything, because the data processor, even though the data processor doesn't have this contact, this interaction with the data subject, with the individual, they still have to provide assistance to the data controller. So what about the data processor's role? So as I mentioned earlier, the data controller must instruct the data processor on what personal data it can use and for what purpose. And it means that you have this requirement actually under the GDPR, under Article 28, to have a contract between the data controller and the data processor, which would specify in writing the obligations of the data processor. And so if you are a data processor, if I wanted to tell you in a nutshell what it meant, is that you have to do what the data controller tells you to do. Finally, the last point, why should you care about the GDPR? Well, first of all, if you are a data processor, well, you can be liable under the GDPR. Commercially speaking, if you are a data controller, well, because the obligations of the GDPR apply to both the controller and the processor, well, as a controller, you're not going to hire and engage a data processor who is not able to demonstrate GDPR compliance and a sufficient level of information security. So if you want to get hired by a data controller, if you want to provide services to other organizations, well, you will need to be able to demonstrate compliance with GDPR requirements. Breach notification, I mentioned earlier as well, means that any problems that you may have may end up in front of data protection authorities. So what I mean here is that if there is a data let's say you have a data breach, and then information was leaked, and then you have customers which complain. The data protection authorities in Europe, they discover about it, they start an investigation. Well, they're not going to stop only at the facts of the incident. In many cases, they're going to look at your security, your security level. They're going to check what you're doing in relation to GDPR compliance. And what has happened was that whenever there is an investigation following a data breach, investigators have looked at lots of different areas, and then they would, when they would issue a fine, the fine would cover all of the different compliance issues and not just the breach related points. For example, I mentioned earlier data retention. Well, what has happened in many cases was that yes, there was a security incident, a data breach, and what has happened was that when the Data Protection Authority conducted their investigation, they looked at different things. For example, how you handle individual customer requests in relation to their privacy rights. They will look at data retention as well. How long are you keeping the information? Is it excessive? Have you collected too much information, and so forth? And all of those different areas will build a case for the regulator so that they can issue a fine which gets higher the more issues they find. And in relation to the fines as well, well, under the GDPR, the fines can go up to 4% of the worldwide turnover or 20 million euros, whichever is higher. And under the GDPR as well, well, you can have private lawsuits which are being initiated. You can have customers who would complain and who would initiate an action. Reputational damage as well is a significant point to bear in mind as well, because in many cases as well, just being in the news that your security level is insufficient, that you don't respond properly within the required timeframes to customers, or that you keep information for an indefinite period of time or whatever. All of those different points could lead to reputational damage and could potentially scare off customers. And so that's about all I wanted to say in a nutshell. So it was a bit of a marathon, if I may call it that way, because the GDPR it's a very long piece of legislation that just so many different points. And I wanted to make sure that to get a good overview of the different key issues which are raised by the GDPR.
Thank you, Paul, for an amazing overview. We do have a couple of questions, so in being mindful of time, we'll just dive right into the questions. This is going back to the beginning around scope. If businesses are collecting information of EU citizens, but the Facebook account was open when the EU citizen was in the US, can you please clarify how GDPR applies in this scenario?
That's a really tricky point, and I'm not sure there's a clear answer to that, in the sense that and the lawyer answer will always be, it depends, because in what context was the Facebook account created in the US? Was it a European resident who was traveling in the US and was on vacation during 2 weeks and then created their Facebook account while meeting up some friends in the US during those 2 weeks? If that's the case, then I would say, well, because you were just in the US on a temporary basis, but then you are still a EU resident, well, it doesn't take away the fact that we are dealing with an EU resident. But then this leads to the second point, would be, well, okay, it's an EU resident because just because that person was in the US for a couple of weeks doesn't change anything. But then, was the organization made aware that this is someone who's only in the US for a short period of time? Maybe, maybe not. Because if, for example, when that person was in the US and created the Facebook account, if they added the United States as their country of residence, then I would say, well, as long as you don't have any evidence that any clue that you're dealing with an EU resident, then there is no requirement, under the GDPR to conduct, an extensive due diligence and to investigate, the residency or the citizenship of individuals or whatever. It's really a question of what are the information which are available to you. So if in addition to the Facebook account, you have, for example, I don't know, an email address, which the extension of the email address is .fr. You have a phone number, which is also a French phone number, or whatever. Then if you have all of those clues, then, it will be difficult to argue that, you thought that it was a US customer because, well, you did have some clues in relation to the fact that, that individual actually has some connections with France. So it really depends, I would say, on what's happening. And there is no requirement as well, that, suddenly because you are dealing with, with a potential EU customer, that you have to that you have to change everything and have an IP check and restrict location or whatever. That would be excessive as well. But then it's also really a question of what are you aware of in relation to those individuals? Are you actively promoting yourself in the EU and so forth? And the reason why I say it depends and it's not an easy question is that in this case, it would really entail a balancing of the different criteria and factors, and to try to to come up with a reasonable conclusion as to whether or not the organization is offering goods or services in the EU. If you are only promoting yourself in the US and then you just happen to have some Germans and some French who would go on the website when they're on vacation in France, then because you're not actively marketing anything in the European Union, you would have good grounds to argue that the GDPR will not apply in that case. But again, it really depends on the facts.
And since you're talking about advertising, this dives perfectly into the next question. If a US-based business that does not advertise in the EU or have any physical presence there, but users trackers or cookies to track users across the internet, would the business be subject to GDPR because it is monitoring behavior of EU residents through tracking?
That's that's another tricky question, and the answer is again not an easy one, because it really depends as well on the volume of customers that you have. For example, if you are small, a small little business, and it turns out that you only have 2 customers in the EU, can you really say that you are monitoring the behavior of EU residents? Yeah, you have those 2 individuals, but then at the same time, it could be, how did those individuals come to you? It could be very coincidental, and in those cases, I don't think that a regulator would suddenly go after that website if they only have 2 or 3 EU residents. But then, in terms of cookies as well, if you do collect cookies, well, you are able as well to keep track of how many customers do come from the EU and so forth. So it also does mean that because of those cookies, well, the regulator would be able to have a bit more certainty as to how much you're actually conducting business in the European Union. So if you do have, again, there is no strict criteria which is set in stone in the law or whatever, but then if you do have cookies and you do have a fairly sizable amount of customers in the EU, then definitely you would have this requirement to comply with the European requirements. If, on the other hand, the amount of EU customers is really negligible, like I mentioned, 3 or 4 customers, and in that case, even though technically you are monitoring the behavior of e-residents, I don't think that a regulator would go after that small business due to the very small volume of customers. So in this case, I think that you would be able to get away with it on a risk-based approach.
Thank you so much, Paul. We are at time, so thank you again for taking your time to join us during lunch. And Paul, thank you for an amazing presentation. We really hope that you all enjoyed learning a little bit about the basics of GDPR and hope you can join us for future sessions. Thank you.